Yeah, personally, I love big dogs, but they don't last. Okay.
Hi, Lisa.
Okay, can you hear me and see me?
Yes, we can hear you and we can see you.
Awesomeness.
And we have
Hey.
some guests or members
Scott?
here.
From Lawson.
Yeah. I wish I could be there in person this year. That was originally the plan, but life had other ideas.
Does the sound okay?
The sound should come
Sound-
through the TV, so we might have to change that setting.
Oh.
We're just waiting for the rest of your crew to arrive.
Yeah, no,
Lisa.
that makes sense. They're walking over, I'm sure. I'm gonna put my headset on. I wonder if I'm gonna sound better with my headset on. Let's try that.
We
I
can
sound
hear you
any-
just fine.
Do I sound better with that or does it matter?
I don't think
didn't
it
matter.
changed.
I think we might have to
Didn't
change.
change? Okay, so if I don't have to wear it, I won't wear it.
Audio. We go to speaker.
This way. Okay.
There. Lisa, would you mind just saying something again for us? I just changed the speakers to the TV.
All right, testing 1, 2, 3. How does it sound?
Much better, yeah.
Okay, cool. I never know with Zoom. It's always a mystery to me whether you sign on the app, do you sign on Wi-Fi? It's just too much.
Yeah.
Too much.
Lisa, are you presenting from there?
Yes.
Okay.
And Catherine's going to be in the room. So Catherine and I usually do this together, and we're usually both sitting beside each other. But in any event, she's going to be there, and I'm going to be on Zoom here.
Okay, and are you having a slideshow to go with the presentation?
No, there's no slideshow. There's a paper that people have been sent a link to, and then I know Toby's bringing some hard copies as well.
Excellent. Okay, good. Then I will take the memory stick out of the computer and we will dispense with that formality. Okay, so we'll just wait for folks to show up and then let you add it.
Yeah.
Okay, super.
Okay, great. Super duper. How's the weather? It's pretty cold, Catherine advised.
Actually, it's quite lovely right now. It's
Oh, is
minus
it?
Yeah, because we
Okay.
have a winter of nothing but minus 35s. Yeah, it's been very cold here all winter.
Hmm. Hmm. Whereas BC's had not enough snow, the snowpack's too low. It's going to be another. I'm glad I got out of the Okanagan because I moved back to Vancouver. It's going to be another bad year, I think, for fires in the interior.
Oh boy.
Yeah, that's good.
We had quite a bit of snow this year. But somebody who knows about this was telling me that unless what really affects the forest here is how quickly the snow melts. If it melts more slow, it can soak in. But if it melts quickly, it just runs off and the lakes fill up, but the forests don't get enough.
Yeah.
So
And that's the same with the Okanagan, and that's what's happened pretty much the last 5 years. Is when I first moved up there, I was high, not as high as Big White, but I was high, and I'd have snow through the end of May. It was gradually melting, and then still coming down from higher. And last year, the snow was gone by early April, gone, even from the higher regions. So then you've got, forest fire season starts in April.
yeah.
Yeah.
And things just bake. By the time June rolls around, everything is already been baked and dry. Yeah, it's a huge concern, especially for the remote communities here. Because they can't get away. They have nowhere to go.
Yeah, no, exactly. Here comes some crew.
Hello.
I know that woman.
Hey, Lisa.
Hey. There's Catherine in her winter gear. Hey.
Okay, good. Organizing all. Did you go to Cambodia as well? Or just-
Yes, for like 4 days at the end. Yeah, basically just.
I met you yesterday, like right outside our
Yeah,
door
I'm
briefly.
different.
Oh, hi,
Thank you.
I'm Scott, nice to meet you.
I think we
I
certainly
like
worked
Cambodia
on the file before.
Yeah, I.
Oh, I like
Yeah.
it. Yeah, very briefly.
Oh,
Because it was so
Scott.
hot.
Hello,
Yeah.
Good.
day off.
Just there. Like, we didn't-
Easter day off?
Yeah.
Are you going to Winnipeg today or something?
Yeah.
It would be
today.
nice to go
For
back
work?
and explore a bit more.
No.
These.
Gotcha. I like Cambodia as well.
Huh,
For some strange, I expected it to be the other way around.
yeah.
Like I really expected it to be the other way.
I'm thinking that you're all here, we're coming, so I'm just gonna close the doors and then that'll keep Axel out, let you enjoy.
Okay.
Otherwise you'll be reading your lap.
Yeah.
You wait.
Yeah.
Service is so good.
I'm assuming we don't have to let people in that are coming in online. Is that our job or is that,
I don't know about that. Oops.
I guess we'll
Well,
find out.
Is a good question
Yeah.
and. Sorry, Toby.
Oh,
Maybe we'll just check.
Well,
that.
I'm gonna have some pizza.
Nobody's there yet, but I'm thinking they'll all, in the next 5 minutes or so, will all join us.
Okay, well. Hopefully, yeah, oh, there. Marcus just popped in, so it looks like they'll just be able to direct right in.
Looks like it. Yeah, looks like we don't need to let them in, so that's good. Okay.
Dave, you doing well? Was your article submitted?
yeah, he's doing fantastic. Yeah, he's unfortunately trying to find work in Toronto. His girlfriend is a.
In my office yesterday.
Oh.
Any tips or anything?
I reached out to my old firm. And they only hired 2 of their 4 students because there's just not enough work. I think that.
Only a couple of years ago, I heard was we can't find lawyers.
How are things where you are, Lisa?
All right. Can't complain, I guess. It's not raining, so that's that's always a bonus in Vancouver.
Absolutely.
So how many are we expecting online? We're expecting about 10 or something online, I think.
15, I think. 15.
Okay. Well, we'll give it it's only 3 minutes too, so I guess we'll do our usual 5 after. What do you think?
Yeah, makes sense.
I wanted to go for pizza. I'm surprised more people aren't here for pizza.
Yeah. Such a beautiful day too. A nice
Yeah.
day to be.
Just to get some fresh air
Yeah.
at lunch, yeah.
Did you go to Mano chocolate place? Rome? You here? Wonderful chocolate everywhere.
Oh, we ate a lot of chocolate. And had a lot of coffee, and a lot of amazing food. The food was the highlight.
Oh, yeah.
Oh, yeah. Street food? Street food, yeah, and the little restaurants where you sat on those little stools.
Yeah, the child size thing.
Yes. Second day we did in Hanoi, we did a food tour where we stopped at 9 different spots around the market and I learned about what different things are called and,
Oh, wow.
sounds so nice. And so that was a really good introduction, because then you'd like know what to order and,
Yeah.
And there was, how many of there were you? Was it?
there were
3
12, there were
families or-
3 families. Yeah, and we had, the first few days we were on our own and then we went on a G adventure, like through a Canadian adventure travel company. But we had, because we were such a large group, we had our own guide,
Oh,
like it
that's
was just us.
Yeah.
And he was fantastic, like there'd be like a mile long line out in front of a restaurant of local, and we just like walk in. And he'd call ahead and have a spot for us, so, or like could anticipate when the kids were fading and would rearrange the schedule, like he was really good. At that, and Paul turned 50 while we were there, and so he did it, we had, like he arranged a fantastic evening for
Oh, wow.
his birthday, was on a lantern boat, like in Hoi An on the river. So,
Wow,
yeah.
that's awesome. That's
Yeah.
amazing.
For everybody that's signing on, we're gonna wait till 5 after, because we always have to give people a few minutes
Yep.
to get online in case they have issues with Zoom.
Mhm.
On the way there, the whole, like 18 hours, so.
We stopped in Seoul. Like Vancouver, Seoul. And then on the way home, we went directly from Bangkok, which was 14 hours.
Better that way.
Yeah. Yeah. The Seoul airport's something else, though. It's huge. And we had like 2.5 hours and we barely made it.
Toby, you have a link to the handout? Cause I didn't register, I didn't know if I would be able to make it or not.
Yeah, it's on the website.
Oh,
Yeah, it's on our
oh, okay.
website. If you just type in, the 25 contract update, even in Google, it should come.
Okay. Thank you.
Yeah, we got a revamped website that now has all of
Oh,
Lisa's
yeah, I
past
saw that
papers.
this morning, yeah.
You guys could go back. and
Yeah, in
get it.
case you're lacking reading material, you can read 10 years worth of papers.
Yeah, actually, but definitely.
Well, I'm glad we have a repository for them now.
Mm-hmm.
They have a similar trip. In Africa, which looks really good. In Morocco
This would be a great resource
Like the
for
kids did really-
schools to,
with the.
Yes, yeah.
Except for right now. which I
Yeah,
think is
yeah,
challenging.
absolutely.
Get back to school.
See, we still got some folks signing on, so we're gonna wait a few more minutes till we are sure that everyone's been able to get on.
My mom's sister.
Okay. We're very supposed to tour. I'm just trying to run.
We were on for a boat cruise, then toured.
Okay.
Well, it is 5 after, Lisa. Shall we launch or should we just give it another minute?
Give it one more minute, I think. Sure.
We,
Yeah,
yeah, we don't end right at the last minute anyway, so.
I think that clock's a bit fast too. I don't know. I've got my
Oh.
phone's telling me it's 11:01 Vancouver time, so that'll be 12:01 your time.
It's 12:02. Okay, yeah, clock is maybe a bit fast.
Yeah, I think that clock's a bit fast. Give it another minute, and then we'll do some intros, and by that time, I think people will be on. We'll give it till 12:03.
Sure.
I'm often the person trying to sign on and struggling, so I have sympathy for anyone that is. Well, let's go ahead. Sure, let's do it because it is a bit of a lengthy presentation. Hello, everyone, and welcome. My name is Lisa Peters. I'm senior counsel at Lawson Lundell, and I'm presenting from Vancouver. I wish I was there with you, and that was the plan, but life doesn't always work out that way. And I'm co-presenting today with my colleague Catherine Whitehead, and both of us are members of Lawson Lundell's Research and Opinions Group. And some of you may have been to our seminars before. Every year for 20-something years, I've been writing a paper that updates contract law from a commercial perspective. And by commercial, I mean both solicitors who are drafting contracts and litigators who are tearing them down. And what we do is every year we look for cases that either give us new insights where the law has changed, or cases that help us remember principles from first-year contract law that illustrate them for us. And of course, if there's Supreme Court of Canada cases on the topic, we also cover that too. And this year is a different from many other years for two reasons. One, Catherine is taking the mantle on this, and next year she'll be presenting contract law update because I'll be retiring later this year. And the second significant thing is that we are talking a bit about some contract interpretation cases this year. We've avoided them in the past, sometimes because they're very fact specific, but there's some important ones this year. Now, the paper link was sent to you. The papers for the last 10 years are online on the Lawson Lundell website. And there's a chart in the back that shows you topics we've covered in previous years, so that if there's a topic we don't cover today, obviously we don't cover every contract law topic each year, you can look there and see if we've covered it recently. So what are we covering this year? And by the way, the presentation goes about an hour and 20, an hour and a half. We usually save questions for the end, because then people that have to get back to court or go back to the office can do so. This year's topics: severance of uncertain contractual terms, statutory signature requirements in the electronic age. This one's have some coffee before I get to this one. Clauses requiring a calculation or determination in accordance with generally accepted accounting principles consistently applied, a formula that shows up in a lot of commercial contracts. Distinguishing between guarantees and indemnities and why it matters. And as always, the update on the ever-growing common law on contractual good faith, the duties of contractual good faith. So without further ado, here we go. So severance. Severance, as you know, is a discretionary remedy that can save contracts where the contract would otherwise be unenforceable. And in my previous papers in 2019, 2023, I talked a lot about severance when there was an illegal provision in a contract. And there's a big body of law on criminal interest rate and severance of terms imposing a criminal interest rate. So I won't repeat what I said there. You can go and read the test in the previous papers. You also may remember me talking, if you came ages ago, about the Supreme Court of Canada decision in Transport North America, Express Inc. and New Solutions Financial Corp., which talked about the two ways in which a court can sever. A court can sever using the blue pencil, which is drawing a line through the term. And there's also the notional severance, which is not always available. But I'd never written before about severance of uncertain contractual terms. And you might think that uncertain contractual terms only show up in contracts that the parties have drafted themselves without the help of able counsel like everyone here. But that's not necessarily the case, as we will see here. And there are a group of cases out of BC and Alberta that provide us some guidance on what's the test for, and when will a court sever an uncertain term in a contract and save the rest of the contract. So the first case I'm going to talk about is a case called Kella and Clark, which is a BC Court of Appeal decision from 2022. And the reason I'm going first with that one is all the later cases cited as stating that the key test. So this was an appeal from the dismissal of an action for specific performance of a contract for the purchase and sale of a residential home. So initially the parties were before Mr. Justice Bernard. They ended up in the Court of Appeal, which upheld Justice Bernard's decision. But let me just give you a little background on the case. Clark listed his property for sale by owner with an asking price of $4.2 million. So this was one of those BC properties out in the valley with all kinds of amenities, a guest house, a pool, tennis courts, koi ponds, very nice property. He then enters into a contract of purchase and sale with this family, the Kellas, for a purchase price of $3.9 million. They set the purchase price 2 years down the road because apparently this guy had a lot of stuff on the property and he had to get it all off the property. So that's quite a late closing date after finalizing the contract of purchase and sale. So there's a price adjustment clause, which is at page 2 of the paper. And again, we see price adjustment clauses in lots of contracts, and it made sense here. It made sense to have one. Unfortunately, the clause itself didn't necessarily make sense. It read in part, it is agreed that the final purchase price is based on the developable area. Any area of the lands that will remain as wetlands, green space, ditch, green infrastructure, watercourses, or setbacks will not be included in the calculation of the final purchase price. If any adjustment is required, the purchase price will be adjusted on a per acre basis. Okay, so that was drafted by the Kella's son, who was a realtor, not a lawyer. 2 days prior to the closing date, the statement of adjustments are delivered to Clark, and the Kellas had adjusted the purchase price down to with a downward adjustment of $1,362,416, so over $1 million, which reduced his take on the property significantly. And he was horrified because he had some tax liabilities and was about to complete the purchase of a new home for himself. So he then finally goes and gets legal advice, which he hadn't done to that point. And the lawyer wrote a letter to the Kellas saying that because this price adjustment clause was vague and ambiguous, the entire contract fell as unenforceable. And they then suggested that the parties could go into a mutual release and return the deposit to the Kellas. Well, the Kellas wanted the property because in the meantime, they'd had the property appraised at 8 million. So they were going to make a windfall on this property. So they, on the closing date, send a revised statement of adjustments at the 3.9 million and advise that they're ready, willing, and able to close. Clark says, no, I'm not closing. So we end up in court action for specific performance or damages in the alternative. Justice Bernard in the trial said, look, there's a true ambiguity here as to what is meant by developable. There were no definitions of that term or other related definitions that could assist, even though extrinsic evidence would be admissible. There wasn't anything that by the conduct of the parties or anything else they did that told us what developable meant. And so he concluded that that clause was ambiguous, uncertain, and it was not severable. So here's the key. He expressed the test, and this is at page 3 of the paper. He said that severance of uncertain terms is limited to those that are meaningless, minor, or subsidiary to an otherwise enforceable agreement or an indivisible part of an agreement. Vague or uncertain terms that the parties intended to govern a vital aspect of the parties' relationship are not severable. The whole agreement has to fall if it's an essential or vital term. And purchase price is, in a contract of purchase and sale of a home is pretty vital. So off they go to the Court of Appeal because the Kellas really wanted this property. They argued that the judge erred in not severing because price adjustment clause was only for their benefit and they were not relying on it anymore. They said that, ironically, if it wasn't severed, Clark would get a windfall, although they were seeking a windfall. And they said that this would be consistent with how the parties had operated. The Court of Appeal said these people are just re-arguing their case. The Court of Appeal said it was open to the court below to find that the price adjustment clause was not an inconsequential term, and the parties intended it to be the method by which the final purchase price, i.e. an essential term, was determined. So there you go. Now that's a case that lawyers weren't involved from day one, but the next case is a case where lawyers were involved throughout. And that's the BC Court of Appeal decision in Kim and Argo Ventures, and this is at page 3 of the paper. The complicated facts, I'll do my best to make them simple. Kim was the plaintiff. He had provided additional financing to a mixed-use real estate development known as the Olympic Village Project. So this defendant, Argo Ventures, through its sole shareholder and director, Mr. Hong, would identify real estate investment opportunities in BC and then pool capital, usually through limited partnerships, and then would manage the real property for these investors in exchange for a management fee. So one entity in which Hong was the sole director and which he and his wife held shares along with other investors was this, and again, there's lots of abbreviations in the cases, this AMF3. And it provided capital for the project by way of an equity investment loan. A second entity, AMF5, loaned money to the project. So off they go. But in 2008, and those of you that were practicing in 2008 will remember there was a recession and the project started to get in trouble. The joint venture partner of Argo Venture pulled out. And so the investors in this AMF3 and AMF5 were at risk of losing their investment. So Argo Ventures did a couple of things. It went out and asked the investors in AMF3 to waive their rights in exchange for interest-free promissory notes from him personally, that were, Mr. Hong personally, that were to mature in 50 years. But that wasn't enough. So they went out, because Hong and Argo Ventures had their fingers in lots of different pies and they had lots of different projects with investors in those projects. Hong went to one of those projects, which was the Raven Song joint venture, and went to these people with a proposal and said, look, I'm going to give you some incentives in exchange for financial assistance to this Olympic Village project, in particular to AMF3. And so the incentives are set out at page 4 of the paper. They would get the incentives if they agreed to have their equity, 2.1 million of their equity, stand as collateral for the Olympic project. So the 3 incentives were additional interest, a reduction in Argo's management fee, and the most important one, a bonus to be paid from a liquidation surplus. As it turned out, economy turned around, the Olympic Village project made a bunch of money. So that last incentive in particular was significant because of the amount. I think it was 30 million of the profit. Now, here's the tricky part. The incentives were not offered to all the people who were invested in this Raven Song joint venture. There was an exclusion clause, which is also at page 4 of the paper. And this is translated from the Korean. which might have led to some of the interpretive difficulties. It said investors of the mutual aid assets related to AMF3 and AMF5 are excluded from the beneficiary list for the incentives. So what does related to mean? Does it mean related to AMF3 and AMF5? Does it mean related to the assets of AMF3 and AMF5? It was 18 million. I see now on the next page of the project made 18 million. I overstated it. Anyways, Mr. Kim, his wife was invested, his family was invested in AMF3. So he was excluded from the incentives when they were paid down, in particular, that last lucrative incentive that came out of the profit. So he sued and said, hey, I should be entitled to the incentive. So they end up in front of a trial judge, and most of the trial was about how you calculate that incentive. But the trial judge also did not exclude Kim and found that Kim was entitled to the incentive because this clause, this translated from the Korean, said the trial judge was vague and uncertain. And so it could be severed according to the trial judge. And so Mr. Kim got his cash. Off they go to the Court of Appeal. And the errors alleged were that the trial judge failed to apply the principle that a term in a contract can only be severed where the remaining obligations can fairly be said to be sensible and reasonable, such as the parties would unquestionably have agreed to them, and erred in concluding that the incentives exclusionary clause was not vital to the agreement. So it's Justice Butler, who actually, it's his reasons on the cross appeal where he deals with the question of uncertainty and in particular severance. And he looked at the surrounding facts and said, this proposal offered 3 incentives, and 2 of those incentives, including the all-important liquidation incentive, were not offered to people who fell within this exclusionary clause. So no matter how badly drafted it was, the agreement contemplated 2 groups who would receive different incentives. He inferred that no additional incentives were offered to investors related to AMF3 and AMF5 because they were already going to get the benefit of the success of the property based on the equity they had put into the property in the first place. He noted that the trial judge adopted that test in Kella and Clark I spoke about, but he concluded that the trial judge erred in applying those principles by ruling that the identity of the parties entitled to that liquidation incentive was not a vital aspect. He said, hey, if you sever out that exclusionary clause, you increase the cost of the incentives to Argo Venture, and you provide increased incentives to parties clearly related to AMF3 and AMF5. So you, by severing it, you are altering the price and parties. And those are vital and essential terms, said Mr. Justice Butler. He said the trial judge erred in effectively rewriting the contract, which is something you're not allowed to do as part of severance. So this case has received a fair amount of commentary, and you can find blog posts online about it. I'm going to summarize the key principles, and this isn't in the paper, this is just me speaking, what people have commented. First of all, severance should be used sparingly and with restraint. Severance must be used only to give effect to the intention of the party. So that's what Mr. Justice Butler said he was doing here. The court must avoid creating new obligations by severing a term. The court cannot resolve uncertainty by making a new agreement that it thinks is reasonable. Fairness or unfairness of the result is an irrelevant consideration, since fairness and unfairness can cut each way. And for the litigators in the crowd, interestingly, Justice Butler got into the weeds with the facts to a certain extent, but he found that the standard of review was correctness, because although the trial judge applied the test from Kella and Clark, he said the trial judge erred in its application of it, and therefore that was an error of law. So they were entitled to a standard of correctness. Now, some Alberta cases that I'll run through quickly. The first one is at page 5 of the paper, Hotchkiss and Budding Gardens, 3-year lease. Interesting clause that for the first year, there was a fixed rent of 7,875. And then the second clause that said in the next 2 years, the parties have to negotiate. Now, what there wasn't was the type of clause you might expect that says if the parties can't agree, arbitration, formula, something. All there was, it said the parties would negotiate. So in an early decision, Justice Eman of the Alberta Court held that that clause was uncertain and therefore of no force and effect. They end up in front of him a second time because he declined to rule on the severability issue because the parties hadn't argued it. So they end up back in front of him again, although the tenant had abandoned the premises, and so the landlord was there in front of Justice Eman. And And again, this adopted the test in Kella and Clark into Alberta law, where Justice Emon cited it and said that's what Alberta law says too. He also cited a significant Alberta case. It's not just cited in Alberta, it's cited all over the place. And that's the decision in Cohen Hillview Homes, a 2012 Alberta case. Because what that case does is it talks about ways in which uncertain terms can be saved, right? So they can be saved by having a reference to a published price or a standard. They can be saved by having an arbitrator or evaluator set the amount if the parties can't agree, or if there's a well-established custom of the trade that can be implied, or if there's some other basis to imply a term. But the judge, Justice Emon, in this lease case said, none of that applies here. I cannot save this clause that just says the parties will negotiate the rent for the second 2 years. He noted that the parties here expressly reserved themselves the determination of rent with a broad discretion, without any guidelines, and therefore he concluded that they must have intended, objectively speaking, that this provision be severable, and severed it. One last Alberta case on severability of uncertain terms, and that's Kaup and Landrex Hunter Ridge. So Kaup had a professional corporation, which I call MKPC in the paper, and he and his company sued Landrex, two Landrex companies, for breach of contract. Landrex then countersues. Parties had two contracts. First of all, there's an agreement for sale by which land owned by one of Kaup's companies, MKPC, would be sold to Landrex. And then there was a second contract, which was a master sales agreement. And that second contract, the master sales agreement, dealt with two things. First of all, Kaup was really annoyed because he felt like the flooding on his land was caused by the Landrex folks on their adjacent land. And so there was a clause that to deal with that required one of the Landrex companies to clean out the ditch. And those are the key words in this contract. There was also a clause dealing with an issue. There had been a approval from the Alberta Environment and Parks allowing the defendants to operate a storm management system on their land. And that was dealt with in this second master sales agreement as well. So the phrase clean out the ditch was a problem. It was not defined or described. Kaup had a real clear idea in his mind. He thought they'd go in there with excavators and dig out this ditch and everything would be peachy. They didn't do anything. The Landrex companies didn't do it. So he sued them, alleging breach of the agreements. They countersued and said, transfer our land under the first agreement because we have a binding contract to purchase and sell, so transfer us our land. The defendants argued that phrase clean out the ditch was void for uncertainty and should be severed. The applications judge concluded that the phrase was vague and uncertain because it did not specify what was to be removed, the volume to be removed, what was to be achieved. He concluded that the parties hadn't really figured out what that clause meant. He went to Cohen Hillview and said, can't be saved. There's nothing here that saves it. The clause clean out the ditch was therefore severed. And the contract was saved, at least at the trial level, but they go up to the Court of Appeal, and on appeal, Justice Harris was with the trial judge. It was void for uncertainty. It should have listed what that meant, clean out the ditch. There was no way to determine what that meant. The applications judge had relied on Hotchkiss, and Justice Harris in the Alberta Court of Queen's bench agreed and said, yeah, that's the test, that BC test from Kella and Clark that's adopted in Hotchkiss is the law in Alberta, but said severance is not available on these facts because here the real focus of that second agreement, the master sales agreement, was to deal with the flooding problem, right? It dealt with the clean out the ditch, and it also dealt with the Alberta environment piece. So she said you couldn't sever it because to sever it would be to make a new deal. So, bottom line. An agreement containing a term that's unenforceable based on uncertainty or vagueness may still be saved where a court is satisfied that severance of the term is appropriate. The test is now, in BC and Alberta and probably elsewhere, that the test from Kella and Clark, it won't be available where the term is an essential or vital aspect of the contract. It'll only be available where the clause is meaningless, minor, or subsidiary to an otherwise enforceable agreement or as a divisible part of the agreement. And again, you can save it. I've set out in the paper the ways you can save it. So those are useful cases if you end up in a battle about whether a clause is uncertain and whether the contract can nonetheless be saved by severance. So moving on to the next topic. In previous years, I wrote about the Saskatchewan Court of King's Bench decision in Southwest Terminal and Actor, and it was also the grist for a lot of blog posts. This is the thumbs up emoji case that you might have heard about. We wrote about it when it came, the trial decision came down in 2023, and we alerted our readers in 2024 that the Saskatchewan Court of Appeal had ruled on it, and that leave had been sought and denied to the Supreme Court of Canada. And the case is really, it deserves a lot more than a blog post, so that's why we've written about it this year, and Catherine's going to take you through the case and a BC case now that's important and creates some uncertainty in the law on this topic. Catherine.
All right, so in the Saskatchewan case, Actor, what happened was, what the question was whether a thumbs up emoji that had been sent by text satisfied Section 6 sub 1 of the Saskatchewan Sale of Goods Act, which requires that a contract be in writing and signed by the party to be charged or their agent. And what happened in this case was the plaintiff, SWT, had purchased grain from the defendant corporation Actor for many years. The agreements were all in SWT's standard form contract. A representative of SWT signed a filled out standard form in ink, took a picture of the front, sent the photo via text to Mr. Actor with the message, please confirm flax contract. Mr. Actor then responded with the thumbs up emoji, no text, no other text, I should say. Mr. Actor did not sign the contract digitally or in ink. Subsequently, he advised SWT that Actor Ltd. didn't consider itself bound by the contract to deliver flax because he hadn't signed it. So the main issue was whether the signature requirement under the Sale of Goods Act was satisfied by a text message simply containing this emoji. Could Mr. Actor be taken to have signed the contract just when he replied by text message containing a thumbs up emote? The trial judge found that the signature requirement was indeed satisfied. The text message consisting of the emoji and the metadata that accompanied it, the court concluded fulfilled the purpose that was associated with the signature. Defendant appealed to the Court of Appeal. The appeal was dismissed. Two appellate judges agreed with the trial judge's disposition. The other disagreed, and this is important because it is relevant to the BC case that I'll discuss next. The dissenting judge found that the text message containing this emoji didn't meet the requirement that a contract be signed by the party to be bound or his agent. He took the view that the signature requirement was intended to introduce an element of solemnity in his mind or attentiveness to the act of contracting that couldn't be satisfied just by a text message that only contained an emoji. In his view, to do otherwise would stretch the signature requirement beyond recognition, ignore the language chosen by the legislature, and be tantamount to a repeal of this particular section of the Sale of Goods Act. So this takes us to the BC Supreme Court decision now that we discuss in the paper. That's Ross and Garvey. At issue here was the signature requirement in section 59 sub 3 sub A of BC Law and Equity Act. And that states that to be enforceable, contracts respecting land or the disposition of land must be in writing and signed by the party to be charged or by that party's agent. So by way of background, the Garvey brothers owned property in Saanich, BC. They created a listing without the assistance of a realtor. Mr. Ross, who is himself a licensed realtor, sent them an offer at the Gmail address that one of the brothers, Kyle Garvey, had provided to him. Mr. Ross used the standard form contract of purchase and sale used in BC, signed the documentation using his electronic signature and electronic initials. Kyle Garvey then indicated by email that the brothers weren't prepared to accept this offer. Mr. Ross immediately replied saying, I won't be submitting further offers. Typically, if you saw things you wanted differently, you would send me a counter offer. So may I ask, what would you want changed? Then Mr. Ross received an email a few days later from the owner's Gmail account, setting out the property address as the subject line, containing a summary of the changes to his prior offer made in an attached counter offer. So this counteroffer changed the price, the deposit amount, the condition removal date, and the completion, possession, and adjustment dates. It set an offer expiry date and time of 9 p.m. on September 25th of 2024. The email also indicated that the Garvey brothers wanted to decrease the buyer's brokerage fee, and Kyle Garvey alerted Ross by text message that this counteroffer had been sent. However, neither brother had signed the counteroffer document electronically or otherwise. Ross then sent a reply email to Kyle indicating that he was accepting the counteroffer. He attached the counteroffer PDF sent by the brothers, added a notation that the contract acceptance date was September 24th. The buyer's deadline for exercising his rescission right was September 27th. And he also attached a document reflecting the reduction in the buyer's brokerage fee. Now, interesting was Mr. Ross emphasized in his email that a counteroffer normally would have been signed and initialed in the appropriate places. He asked the brothers to do so as soon as possible. Then in a subsequent text message, he stated again that he had sent an accepted counteroffer and asked if Kyle Garvey had any questions. Kyle then responded with a thumbs up emoji. When Ross again asked that the brothers sign and initial everything, offered to send them the materials through DocuSign, Kyle responded that he would not be able to accomplish that night, given his and his brother's schedules. He said he would have his lawyers look things over and discuss it with his brother and get back to Ross. Ross's next text made it clear that from his perspective, there was a binding accepted offer that should have all signatures attached. And so he stated, when you send me a counteroffer and I accept without changes, that is done. And the date of acceptance is today. There isn't another round. The next email Ross received from the brothers was not from the owner's Gmail account, but from Matthew Garvey on his Gmail account. He indicated that his brother was dealing with a medical emergency. All future communication should be directed to him. And Ross ultimately heard from the lawyer for the brothers that their position was that they did not enter into a binding agreement to sell the property to him. He proceeded to file a notice of civil claim against them, asserting that he accepted their counteroffer, thereby creating a binding and enforceable contract. He sought an order for specific performance or in the alternative damages. So the court found that at the date of the counteroffer, Kyle had apparent authority to act for his brother, and the court also found that a contract of purchase and sale was indeed formed between the parties when Ross accepted the counteroffer sent by Kyle. The question was whether the contract was enforceable against the Garveys, even though they didn't sign it. Now, Ross acknowledged that they had not indeed affixed traditional signatures. He urged the court to broadly and purposefully interpret Section 59, sub 3, sub A to find that they had signed the contract by communicating the counteroffer electronically to him in the manner they did. One of the factors that was raised in the argument was the thumbs up emoji that had been sent by Kyle in response to Mr. Ross's text, confirming that the counteroffer had been accepted. And the court ultimately agreed with and adopted the reasoning from the dissenting judge in the Saskatchewan Court of Appeal decision. That was Justice Barrington Foote. His dissent was what the court ultimately went with, and he concluded that while a signature need not be a traditional handwritten signature, the contract has to bear at least some sort of formal inscription made manually or electronically that reflects the identity of the party who made it. In his words, in doing so, there is some assurance that the signatory not only wishes to be bound, but also appreciates the significance of the act they have agreed to. So simply sending a document from a particular email is not enough for the document to be considered signed, nor does sending a separate text with a thumbs up constitute a signature on a contract for the purpose of this provision of the Law and Equity Act. So the bottom line is that many statutes contain signature requirements for specific types of contracts, some of which were originally in place long before there was any ability to sign a document other than just in wet ink. And these provisions will necessarily interact with the given jurisdiction's electronic transaction statutes, which are permissive as opposed to mandatory. And what these cases demonstrate is that when an agreement is formed by way of an online communication and the parties don't sign in ink or via electronic signature software, an opening is created for a party having second thoughts about the contract to argue that the contract is unenforceable because it didn't comply with a statutory signature requirement. The question arises as to what other content in a text or an email can constitute a signature. We now have examples of courts taking very different views of how far they can go to construct a signature out of content in an email or a text. We have the majority decision in the Saskatchewan Court of Appeal concluding that metadata and an emoji in a text can indeed constitute a signature. We have the minority decision in the same case, along now with the BC Supreme Court decision concluding that the contract has to bear at least some sort of formal inscription. And this is certainly not going to be, we highly doubt this will be the last word on the matter. People will continue sending text with emojis indicating their assent to things, and courts will have to grapple with this question in the future.
So next topic, and this one, put on your seatbelts. A disclaimer at the beginning: I'm not an accountant. I do not have a commerce degree, but I was fortunate enough to be able to consult with some of the lawyers here at Lawson Lundell who have both degrees to deal with this, because this is all about generally accepted accounting principles and GAAP clauses, as they're called. It turns out that this type of language, referring to GAAP as a formula of some sort for calculation in an agreement, is very common in commercial agreements. And so I realized that courts have grappled and often struggled, because judges, perhaps like me, don't always have an accounting degree, with what this clause is meant to do and how to interpret it when there's a dispute between the parties about such a clause. So the first case is Evergen Infrastructure, which is a 2024 BC Court of Appeal decision. Evergen sought leave to appeal the award of an arbitrator. The arbitrator was dealt with post-closing adjustments under a share purchase agreement. So a very common thing under a share purchase agreement, you have post-closing adjustments between the parties. Under the share purchase agreement, Evergen was buying the shares of Sea to Sky Soils and Composting, and the post-closing adjustments included the current liabilities of Sea to Sky, and that term, current liabilities, in a very comprehensive commercial agreement, was defined. Liabilities of the corporation, which in accordance with GAAP are shown on the balance sheet of the corporation as current liabilities, including without limitation, and so on. And this is at page 16 of the paper. The primary asset of Sea to Sky was a composting facility, and the Ministry of Environment had issued a non-compliance advisory letter that identified specific areas of non-compliance with the organic matter recycling regulation. So in the post-closing adjustments, Evergen recorded the amount of $550,000 as a current liability, drawing the amount from an estimated receipt for the construction of a pond. So they hadn't dealt with their non-compliance under this organic matter regulation, but they had plans underway to deal with this non-compliance, and they'd got an estimate of building a pond, which the arbitrator had found would resolve most of the issues relating to the MOE advisory letter. The respondent said Evergen had failed to provide a fair, accurate statement of the calculation of the closing working capital. So the only issue on which they sought leave to appeal was the arbitrator's finding that the MOE accrual was not a current liability under GAAP and therefore couldn't be included in the determination of current liabilities. So before the arbitrator, both experts relied on the three-part definition of liability found in the CPA handbook, which I put in the footnotes for your reading pleasure, and the three elements that must be met for an amount to constitute a liability. The arbitrator found that these three elements were not made up by Evergen. The arbitrator concluded that the MOE accrual, i.e. this amount for the pond that they were proposing they would spend, was not a current liability and not a liability on closing. So the problem for the appealing party was that appeals from an arbitral award under BC's Arbitration Act, and this is true under most arbitration acts, are limited to questions of law. So Evergen's counsel had to come up with errors of law made by the arbitrator, and they made a mighty attempt to do so. They said that the arbitrator incorrectly interpreted GAAP to require an actual expenditure of money, that the arbitrator incorrectly determined that compliance with that order from the ministry was discretionary, and that the arbitrator erred in failing to consider a relevant element of the legal test under GAAP, that being whether the MOA accrual amount constituted a constructive liability, which is something that's described in the CPA handbook. The problem was there's a long-standing body of law, including 2 decisions of the Supreme Court of Canada, that stand for the proposition that GAAP is not law, and determinations made under GAAP are findings of fact. And Evergen could not produce any authority to the contrary, and had to concede that GAAP, along with the CPA handbook, provided the only framework for these errors of law that it had articulated in its leave application. And one last attempt, Evergen contended that by including a reference to GAAP in the share purchase agreement, the principles of GAAP effectively became the party's own private law, or alternatively were elevated to legal principles because the party had included them in their agreement. Madam Justice Fleming was having none of it. She said the jurisprudence recognizes that GAAP is a non-legal tool, and findings based on GAAP are findings of fact. And you can't elevate factual things to law by agreeing to them in your contract. So that's an important case when people are picking their dispute resolution clause, because if you have an arbitrator evaluator determining issues based on a GAAP formula, you may not have much luck getting leave to appeal. Before I go to the other cases, though, there's an aside here of things I learned in writing about these cases and plowing through the expert evidence in these cases. A lot of these clauses just refer to GAAP, and it's more complicated than that. In 2011, Canada made a strategic decision to align with global accounting practices and adopted something called IFRS, International Financial Reporting Standards. Those are mandatory for publicly accountable enterprises. Private corporations can follow IFRS, but can also choose ASPE. The accountants love their acronyms. Further, as I say in the paper, there's 2 other standards for certain types of nonprofits. And as we understand it, in talking to people that know more about this than me, there are differences among the standards. So GAAP is kind of like an umbrella now, and there's these 4 different standards under. And by the way, if you're looking for a good discussion of this, I'm going to hold this up. This book, which may be in your courthouse library, Beyond Boilerplate, has a good discussion of all these different standards and what's happened over the years, which I found helpful. So what's interesting is that the agreements maybe haven't caught up with these different standards. And if somebody just refers to GAAP, there could be ambiguity about what they're talking about. And I've put some footnotes in where commercial solicitors have assisted me in saying, look, we may just say GAAP, but then we define it. So we may say GAAP so that it's short in the body of the agreement, but we define it comprehensively to refer to the standards that the particular entity or entities use. And that's a way of clarifying. But people should think about what they're saying when they refer to GAAP. The other thing, which is going to come up in one of the cases I'm going to get into, is there's US GAAP and Canadian GAAP. Who knew? Unless they were an accountant. And US GAAP, in fact, has differences from Canadian GAAP, which comes back to bite one of the litigants in this year's paper. So without further ado, I'll jump into the cases. Leader Automotive, this is at page 17 of the paper, which is the Ontario Court of Appeal. I talked about it in 2023 because it's also an important case on shotgun clauses in unanimous shareholders agreements. What this case was about is a guy named Warwick owned shares in Leader Automotive. He indicated his intention to sell, and Leader indicated it's an agreement to buy back his shares. The corporation was going to buy them back, but it fell apart because the CEO of Leader and Warwick got into a dispute, and he decided he wasn't going to sell. Leader then seeks to compel him to sell. And so there were issues around whether the share purchase transaction was a separate standalone contract, which I dealt with ad nauseum in 2023. But one of the other issues in the case was whether Leader had repudiated the contract by certain conduct. The valuation clause, and this is at page 17 of the paper, required that the corporation's auditors or accountants use generally accepted accounting principles applied on a basis consistent with those used in the preceding fiscal year. So another one of these GAAP formula clauses. Problem is that when Leader's accountants sent the draft financial statements that year to Leader's CEO, there was a cautionary note from the accountants that said, paragraph 12.1 requires GAAP financial statements being a review or audit engagement. The draft financials are a notice to reader engagement only and are not GAAP. Apparently this was as requested by the CEO of Leader. There was another problem. Leader had received a $5 million settlement in the Volkswagen TDI emission scandal that was conveniently left off of the financial statements. So Mr. Warwick said they breached the valuation clause when they valued my shares because it wasn't consistent with GAAP. Leader, and of course the note from the accountants was front and center. Leader said, oh, well, that article doesn't require formal compliance with GAAP. It's something short of GAAP is good enough. That you should interpret that language applied on a basis consistent with those used in the preceding fiscal year to allow us some wiggle room. And I've given you the quote from the Ontario Court of Appeal where the court said, this amounts to the proposition that in 2003, the shareholders intended that down the road, the exchange of potentially millions of dollars worth of shares would proceed on a GAAP-light basis. So the Ontario Court of Appeal was having nothing to do with it. So another case, and it's amazing to me actually how often these cases come up and judges are forced to grapple with expert evidence. And another point is that these clauses being disputed becomes expensive because there's expert evidence on both sides. Because what I've learned as well is that GAAP does not draw bright lines, and there's different ways to interpret it. And again, there can be disputes about which version of GAAP are we talking about, so it becomes very costly. And this next case is an example. So this is Anthem Capital and Appliance Recycling. Here, the parties actually expressly reference U.S. GAAP. The ARCA, Appliance Recycling Centers of America, was a publicly traded U.S. corp, and it did appliance recycling in the U.S. and Canada, but it carried out the business in Canada through a subsidiary, ARCA Canada. So ARCA Canada retained Anthem, the plaintiff, which was a personal services corporation of a guy named Joe Berta, and there were two agreements. And what Anthem did for ARCA Canada was manage the appliance recycling all across Canada. And each of the agreements contained a formula for the compensation to Anthem, and each was based on the net profit on services delivered in Canada through ARCA Canada, and net profit was to be determined by subtracting total expenses from total revenue before taxes, and here come the magic words again, calculated in accordance with generally accepted accounting principles of the USA, consistently applied. ARCA was supposed to produce an income statement for ARCA Canada, its subsidiary, in accordance with US GAAP within 90 days of each fiscal year, and Anthem was entitled to inspect them. Berta wasn't making much money on this deal and got quite upset and expressed his concern about the calculation of fees owing under the agreements. The particular point that he took issue with was the allocation of the parent, ARCA Corporate, its overhead to ARCA Canada. So they end up in litigation. And the focus of the claim was whether ARCA, in preparing the annual income statements for ARCA Canada, allocated ARCA corporate overhead costs in a manner that was not in accordance with US GAAP consistently applied, therefore cutting into Mr. Berta's profits. The parties led a lot of expert evidence, which I poured through. And of course, the experts take different views on a number of different things, and the court goes through them in detail if you're interested in reading about it. The onus was on Anthem to prove that the financial statements were not in accordance with US GAAP. Berta acknowledged at trial, and this is a practice point. He acknowledged that he had no specific knowledge about US GAAP required when that was put in the agreement. He was just content to go along with it. So whoever was advising him didn't explain to him that it might be different from what Canadian GAAP said. The Justice Broad goes through the expert reports in detail. He held that the parties had agreed on the application of external principles, i.e. US GAAP, that would guide the calculation of net profit, that were recognized and shared on a societal level, and not on a set of detailed and prescriptive rules. So he's saying, look, GAAP is not a bright line. It's not like a strict bright line test. Rather, these are shared principles. The agreements between the parties delegated to the ARCA parent the task of determining ARCA Canada's net profit for the purpose of calculating Anthem's annual compensation, and provided only that the calculation be done in a way that accords with or agrees with or follows US GAAP. And this part, some solicitors may disagree with this finding. Justice Broad found that consistently applied refer to the application of US GAAP and not necessarily particular methodologies chosen by ARCA. The plaintiff tried to argue that they had to be consistent every year, and therefore they hadn't complied in some way and led evidence on that. Ultimately, Justice Broad concluded that the experts agreed that the allocation of corporate overhead costs by a parent to a sub was not governed by a strict set of rules, which would provide a bright line. This led him to the conclusion that there could be a range of available allocation methodologies that could be considered rational and reasonable. Therefore, it was open to corporate financial management, i.e. the parent company, to exercise its own discretion in selecting the allocation methodology. An assessor or adjudicator charged with determining whether the allocation of corporate overhead costs was in accordance with US GAAP is required to be deferential to the exercise of management's discretion. So Mr. Berta and Antim were hooped because they had delegated it effectively, according to Justice Broad, to the parent company. And as long as it was rational and reasonable and within this broad landscape of what US GAAP would allow, was done. There is a case in the footnotes that I won't get into, but that you should be alive to, at footnote 24, I believe it is. There's a mining case involving net smelter returns, and which is important if you're dealing with mining cases. And what's happened to that case, I put that case in there because there was expert evidence on both IFRS and US GAAP, because both were important, which made the case even longer. That case went to appeal. And so the Court of Appeal decision, if you want to look at it, is 2026 BCCA 6. There's a ruling on the GAAP issue in the trial decision. In the Court of Appeal, Justice Griffin said that the error made by the court below was allowing the expert evidence to outweigh just plain old interpretation of the contract, which is interesting. So let's get to the bottom line. Parties, I've learned, frequently choose GAAP. They insert GAAP as some way of making a calculation. Sometimes they're referring to specific financial statements, and the financial statements matter, so the net profits will be determined in such and such a way based on the financial statements of one of the entities. But sometimes they use GAAP, as they did in the net smelter case, in another way. If you choose to do this, some warnings. GAAP is not law. It does not articulate a legal test. Findings by a lower court or arbitrator based on GAAP are findings of fact, and so you may not get leave to appeal if leave to appeal is required. Based on what Madam Justice Griffin said in the net smelter case, a reference to GAAP can't trump the other parts of the agreement. You can't use that to oust principles of contract interpretation. If there's a dispute rooted in the calculation that includes GAAP, you're going to end up in expensive litigation. All these cases are hundreds of, 100+ pages long because experts battled over what was meant by the clause and what was meant by GAAP. So be aware. Ways of avoiding that obviously are to have disputes between the parties relating to the GAAP related calculation referred to evaluator or arbitrator, maybe not even an arbitrator, but evaluator that's not appealable. I also set out again in the bottom line, remember there's now all these different standards under the broad term GAAP, so be careful about what you're referring to. I find the phrase in accordance with GAAP consistently applied to be awful passive voicey. Yet solicitors use it over and over again. And again, there's some issues around consistently applied by whom and when. So don't just copy what I saw in looking at this jurisprudence and some earlier jurisprudences. People just cut and paste these things, and they ought not to do so because it should be designed for the specific transaction. And the lesson we also take from the Antim case is your client better understand what that means, what that formula means. Mr. Berta didn't understand what US GAAP did in terms of his profits before entering into the agreement. So next, contractual guarantees and indemnities. Why do we care about them, the difference between them? And we all know that commercial agreements almost routinely now, it seems, include indemnities. As another way of, you have a claim for breach of contract against your counterparty if they breach, but commercial solicitors like to include indemnities as well. So guarantees, if you read the authors, and the leading author is still Kevin McGuinness, although his book hasn't been updated in some time, guarantees are kind of a indemnity agreement. Whether something is a guarantee, though, or more broadly, an indemnity that's not a guarantee, is a question of contract interpretation. Why does it matter? Well, we're going to get into that. because it does matter for a number of reasons. The case that's highlighted in the paper is the Alberta decision in WBI Home Warranty and Patel. In Alberta, as you may know, if you do transactions involving Alberta parties, they have this Guarantees Acknowledgement Act, which is a fairly unique statute for Alberta. And what it does is it imposes requirements for guarantees entered into by an individual, a person who's not a corporation or other type of legal entity that involve appearing before lawyers and signing a form of certificate. So WBI was an agent for Royal and Sun Life Insurance. It sold home warranty insurance underwritten by RSA as agent for RSA to home builders. Home builders in Alberta had to get home warranty insurance because of an act called the New Home Buyer Protection Act. So WBI sells this insurance, this RSA insurance, to this company, Optimistics, which is called the builder in the case, under an agreement referred to as the builder agreement. But there's a companion agreement, and it's called indemnity agreement. And alert, what you call it doesn't necessarily matter. Indemnity agreement in which the corporation, the builder corporation, and 3 individuals sign. Under that agreement, these defendants say, we're going to indemnify the insurance company from any loss it might suffer if we fail to meet our obligations under the respective agreements, both the home warranty insurance contract and this indemnity agreement. So, of course, the inevitable happens. The insurance company suffers a loss, seeks indemnity from the builder and the individuals. The individuals try and get out from under because it's a bunch of money that they don't want to have to pay personally. They say, oh, this was a guarantee and it's unenforceable because they didn't comply with this guarantees Guarantees Agreement Act and Guarantees Acknowledgement Act. The Guarantees Acknowledgement Act voids the guarantee if you don't comply with going before a lawyer, having it signed by the party. So they end up in the Court of Justice, which is the lower court, like a provincial court in Alberta. That judge said it's unenforceable, it's a guarantee. And the judge took a fairly simplistic approach to it, saying it required the respondents to answer for the builder's default. So it was a secondary obligation, not a primary obligation. So therefore it must be a guarantee. Oh, that it were that simple. We learn in the cases that it's not that simple. They go to the Court of King's Bench. And Justice Kuntz looks to the Guarantees Acknowledgement Act and notes that there's a definition of guarantee as meaning a deed or written agreement whereby a person not being a corporation enters into an obligation to answer for an act or default or omission of another. Now, this is a very learned decision. It's very specific to its facts on one level, but on another level, it's a case I will go back to again and again to understand how I'm going to argue something's either a guarantee or an indemnity. She goes first to the McGuinness text. And the most recent edition is 2013. Not sure why that's so. Because Kevin McGuinness is still writing on many topics. She said, while the starting place is the distinction between the two is conceptually clear. Indemnities relate to protection against loss or liability. Guarantees relate to protection against the default in performance of another person. But, she says, it's not that simple. It's not that sharp. For instance, if one party induces another to enter into a transaction by a promise to indemnify against liabilities that might arise, that's not a guarantee, that's an indemnity. And McGuinness, in his text, he quotes extensively from it, but he says that in the case of a true guarantee, what he calls a true guarantee, the promisor has no connection with the transaction except through his promise to pay. Whereas if the promisor is involved in the transaction through some larger transaction, it's indemnity. Now, McGuinness's book is an entire book, and obviously I can't summarize it here, but there's a good explanation of what McGuinness says in this judgment. Justice Kuntz doesn't stop there. She goes back and looks at the common law on that draws distinctions between guarantees and indemnities for the purpose of the statute of frauds. In your jurisdiction, in NWT, you still have the original statute of frauds from 1677, and so does Alberta. Other provinces have modified it somewhat. In BC, it's our Law and Equity Act. And under the statute of frauds, guarantees had to be in writing. And so it mattered whether something was a guarantee or an indemnity. And so what Justice Kuntz does is look at these older cases, Alberta cases, one of them being Kamitomo and Pasula. And in that case, there are no less than 3 different tests from the English common law on distinguishing between something being an indemnity or a guarantee. And I won't take you through all of them, but they're all come to much the same approach. So the first test says a promise made to a person who is a creditor or about to become a creditor to pay the debt due or to become due from another creditor is a guarantee, whether the promise to pay is conditional or unconditional, whereas a promise made to one who is not a creditor, that if he will incur liability, the promiser will indemnify, that's an indemnity. But if the object of an agreement between the plaintiff and defendant is to induce the plaintiff to assume a liability, which does not then exist and is being assumed as a consequence of the agreement, then a promise of the defendant made incidentally thereto to pay the debt of a third party is an indemnity. And then there's different ways of stating this in English cases. One's called the interest test and one's called the object test. It's all set out there, and it's set out in great detail in Justice Kuntz's reasons. So she had to apply these tests. She applied all three of the tests, which really are the same. They're just stated in different ways, to determine whether this thing that was called an indemnity agreement, which was signed by the company and also signed by these individuals, whether it was a guarantee or an indemnity. She noted that one of the individual signatories was a director of the builder, who signed it both on behalf of the builder and in his personal capacity. While there was no evidence of whether the other two were directors, officers, or shareholders, the builder agreement stated that the insurance company may require such persons to sign. And she concludes that the object of this whole transaction was the builder agreement. The builder and the respondents needed the insurance because they had to get that insurance to comply with the statute that applied to new home builders. They all stood to gain from the builder agreement because it was necessary to keep their company, the builder, in business. And they induced the insurance company to enter into the builder agreement and assume a potential liability to the homeowners if something went wrong by promising to indemnify. So therefore, the builder agreement requires the builder to remedy and repair defects that are subject to a valid claim by an owner under warranty policy. The warranty policy is between the owner and RSA. If the builder fails to make a required repair, the builder is in default and RSA steps in. In my view, this structure is inconsistent with the idea that an indemnity agreement is a guarantee. The builder agreement creates its own set of obligations between the builder and RSA in response to the legislation. The respondents did not agree to answer for the builder's default in that specific context. They weren't standalone people who were just coming in and guaranteeing, but rather it was all bound up together. And then she went and linked through the various clauses that supported her conclusion. So she construed the agreement to be an indemnity agreement, not a guarantee. So they didn't have to comply with the Guarantees Acknowledgement Act, and the individual guarantors were on the hook. What this case tells us is that you have to remember that the statute of frauds is out there, and certain types of, you have to look at your own jurisdiction's jurisprudence and the jurisprudence of other jurisdictions in terms of what things the statute of frauds requires to be in writing. And as Catherine noted when talking about this, the emoji cases, there are lots of statutes requiring certain agreements to be in writing, and there's also lots of statutes requiring them to be signed by the parties. The statute of frauds requires guarantees to be evidenced in writing, and that is a reason to distinguish between guarantees and indemnities. It will matter whether or not it's in writing if you want to say that it is a guarantee. And we've given you in the footnotes a fairly exhaustive explanation of differences in the statute of frauds in every province. Unfortunately, there's not uniformity, so be careful. That's a trap to the unwary. In BC, as it happens, both guarantees and indemnities are under the Law and Equity Act and have to be in writing. McGinnis probably said it best, this is at page 24 of the paper, when he says, the law applying to the statute of frauds is both confused and complex because the judiciary throughout the common law world has often expressed its hostility towards the statute of frauds, and they have, for the most part, almost since its enactment in 1677, consistently striven to find ingenious ways of circumventing its effect. So it does matter whether something's a guarantee or indemnity. Obviously, if you're dealing in Alberta with individual people that have signed this thing that's purported to be either an indemnity or a guarantee, if they're individuals and it's a guarantee, you have to comply with that Guarantees Acknowledgement Act. But the statute matters as well when you're dealing with the statute of frauds and whether if it is a guarantee, whether it complies with the statute of frauds. There are a number of other reasons that I've set out in the paper. Perhaps most importantly, an indemnifier is liable even if the principal debt is void or otherwise unenforceable, which is not the case with a guarantee. So if the principal debt falls away and you are a true indemnifier, they can still go after you as long as your contract's enforceable. That's not true with a guarantee. A guarantee, if the principal debt falls away, so does the guarantee. While the normal defenses arising under the law of contract apply to both indemnities and guarantees, the law of guarantee affords sureties with what McGinnis describes as a staggering array of defenses. Now, if you've ever had one of these cases involving a guarantee, you'll know that people throw the kitchen sink in terms of defenses to a guarantee. So the difference matters there. And there may be different limitation periods that apply. So while it may be difficult to distinguish a contractual indemnity from a guarantee, there's all these important reasons to do so. The use of a label will not be determinative, and nor will the fact simply that the obligation is secondary. That was the mistake made by the lower court judge in this Alberta case. The resolution in each case will turn on the correct interpretation of the contract and the intentions of the parties. And if I ever have to do this again, which maybe I won't before I retire, but I would turn to this Alberta decision because it really is a comprehensive review of the test you can apply to make the argument that it's indemnity or to make the argument it's a guarantee. So the last topic, which we always cover every year, is our friend good faith in contract law, good faith obligations in contract law. So over to Catherine to wrap it up with that topic, and then we'll take questions at the end.
All right, so we have 3 cases which we felt offered some clarity on questions that the trilogy, so that's Basine, Callow, and Wastech, didn't answer. The first case, Ocean Pacific Hotels. In this case, the BC Court of Appeal considered whether pre-contractual negotiations can form the basis for a claim based on a breach of a common law duty of good faith. In this case, Mr. Justice Butler ultimately endorsed the developing consensus throughout the case law that a claim for breach of the duty of honest performance cannot be based on dishonest conduct allegedly connected to contract negotiations. So really that's, could pre-contractual dishonesty give rise to a claim of breach of the duty of honest performance? Mr. Justice Butler said no. What happened in this case was the appellant, Ocean Pacific, operated the Pan Pacific Hotel in Vancouver. The respondents were former employees who had agreed in 2020 to change their employment status to casual after Ocean Pacific was unable to offer regular shifts to many of them due to the COVID-19 pandemic. Employees who changed their status and signed agreements for casual employment stayed eligible for extended health benefits, subject to and in accordance with the terms and conditions of the applicable plans and policies and the continued approval of Ocean Pacific's carrier. Casual employees were normally not eligible for these benefits. Ocean Pacific was able to extend coverage for during a 120-day grace period under its terms with the insurance provider. But in July of 2020, the grace period was expiring. Ocean Pacific still didn't have sufficient work for most of its regular hourly employees. In response to employee questions regarding the casual agreements, Ocean Pacific said, current benefits, which are subject to the rules, regulations, and policies of the provider, will remain the same. Ocean Pacific did obtain a second extension, which then ultimately expired in January of 2021. So the employees commenced a class action against Ocean Pacific. They alleged that it had promised them that when they signed these casual agreements, that their extended health benefits would be extended indefinitely. The Chambers judge initially declined to certify the class action, but then gave the employees the opportunity to amend their pleadings to produce a potentially viable claim. They advanced a new theory of their case, that there was an implied term in the new employment agreements for casual employment that Ocean Pacific would take reasonable steps to obtain the insurer's continued approval to provide these extended health benefits. And they revised the legal basis for their claim for breach of the duty of good faith contractual performance. They pleaded that Ocean Pacific had made dishonest statements about the terms of the new agreements and had failed to inform them that it had only arranged for benefits covering for a temporary grace period. Chambers judge concluded that there was some prospect that this claim might succeed at trial. However, on appeal, Mr. Justice Butler concluded that the SEC had not intended to create a good faith duty that could apply to pre-contractual negotiations when it recognized the existence of this contractual duty of honest performance. In his view, the torts of negligent and fraudulent misrepresentation provide an adequate remedy. The employees could have advanced a claim in fraudulent misrep based on the same material facts pled in their amended notice of civil claim, but they had not done so. All right, the second case that we're looking at asks the following question. What constitutes a contractual discretion that gives rise to the good faith duty that was the centerpiece of Whitehead? As made clear in Whitehead, there is a duty to exercise contractual discretion in good faith, and this operates in every contract irrespective of the intention of the parties. We previously noted that it's uncertain what types of contractual obligations or powers should be properly characterized as discretionary, and therefore subject to this duty, because almost any power under a contract can be described in a general way as discretionary. A party can choose to exercise it or not. However, in this case, Crotty and Aviva General Insurance Company, the Court of Appeal of Newfoundland and Labrador helped to resolve this uncertainty by considering what constitutes a contractual discretion in the context of assessing whether the terms of a standard automobile insurance policy gave the insurer, in this case Aviva General, the discretion to decide whether claimed travel expenses were reasonable. So what had happened was the appellants had been injured in motor vehicle accidents. They claimed that Aviva General had wrongly denied them reimbursement for expenses that they had incurred for travel to treatments. The lower court characterized the contractual obligation for Aviva General to pay reasonable expenses as a discretionary term. And because the appellants hadn't alleged that the insurer had exercised this discretion in an arbitrary or capricious or bad faith way, their amended statement of claim didn't set out a viable claim for breach of contract. Court of Appeal disagreed that the contractual obligation to pay reasonable expenses was a discretionary term. It characterized contractual discretion as follows, and we set this out because this is the sort of the key passage. A contractual discretion does not arise because a party has a choice how to execute a contract. It arises when a party has the power not only to choose, but to bind the other party to that choice. The court applied that reasoning to the policy in this instance and concluded that the terms of Section B imposed on Aviva General an obligation, not a discretion, to pay reasonable expenses. Aviva General can choose whether it considers an expense reasonable, but so can insured persons when they submit their claim. Neither party has the discretionary power to decide whether an expense is reasonable and then bind the other party to that choice. And in this case, because Aviva General was not exercising a discretionary power, the appellants didn't need to allege that it had exercised that power contrary to the requirements of good faith. Finally, with the last case, which is a bit of an interesting case, and perhaps gives rise to more questions than answers. The question that we say that this case sort of grapples with to some extent is can a breach of a good faith duty occur in the context of a letter of intent? So what happened here was there was a letter of intent concerning the sale of an endodontic practice between two dentists, Dr. Eamon and Dr. Sevo. Dr. Eamon was transitioning into retirement. Dr. Sevo wanted to purchase his practice. The LOI set out a series of steps and conditions precedent that were required to be completed and met prior to the purchase of the practice. The LOI expressly stated it was not contractual in nature or binding, except as specifically set out herein, and reflected only the intention to proceed towards the negotiation of the purchase agreement. Dr. Sevo ultimately decided to terminate the purchase. Dr. Eamon argued one, Dr. Sevo's failure to finalize and sign the lease agreement with the landlord, and two, the manner in which Dr. Sevo exercised his contractual discretion with the LOI, and three, his ultimate termination of the LOI and transaction, each amounted to a breach of the duty of good faith and honest performance. Ultimately, Justice Horvat found no breach, but really what is not set out in the reasons is how the duty of good faith performance could apply to the terms of the LOI that were expressly non-binding. So for the bottom line with this case, it seems to suggest that contractual duties of good faith performance, and good faith exercise of discretion could apply to a non-binding LOI. No such breaches were found on these facts. We both think that it would be a startling conclusion. It may be that the case can be explained on the basis that the LOI did contain some binding provisions. Council was relying on those provisions perhaps when raising the good faith duties, but it does give rise to this question. Quickly going through, the bottom line for Ocean Pacific was that good faith duty of honest performance doesn't apply where one party claims that it was dishonestly induced to enter into a contract. There would otherwise be an exponential expansion of remedies for breach of this duty in the Court of Appeals view. And the decision in the Aviva General case affirms what we've previously opined about Waste Tech, is that the SEC didn't intend to label every contractual power as a discretion. It applies to contractual terms that permit one party to make discretionary choices that then bind the other party. So that is determine that party's contractual rights. So that was a bit of a lightning round. Lisa, did you have anything to add about the LOI case? I know you.
Oh yeah, the LOI case, it completely bemused me when I read it. And I've seen actually blogs posts that suggest that the law is now that you can sue for a duty of good faith under a non-binding LOI, which I don't think the case says that. I think the problem with the case is we don't really know. The parties did a lot of the things by agreement before the judge, and so we don't really know what terms they were relying on. I think it would be inconsistent with the existing body of law to suggest that they could rely on some of the non-binding terms, i.e. the progress towards the actual purchase agreement. They could rely on a good faith duty in that context, because we have tons of cases saying, no, it doesn't apply pre-contractually. It illustrates the danger of these LOIs, because of course, if any of the solicitors in the crowd know, you have a bunch of terms that are binding, like confidentiality, for example, and then a bunch that aren't. And that can obviously be fraught with some peril, according, based on this case. I think we'll see more. I don't think this case is a precedent for there being a duty of good faith in relation to non-binding terms of an LOI, but I guess we'll see. And I guess Catherine will keep an eye out for next year to see if there's any others. So that's all we had for you today. We're happy to stay around and answer any questions or comments. As we've said, the paper's online, the cases are linked there. If you want to read some of that expert evidence on GAAP, if you're not getting to sleep at night, that's a good way to do it. Anybody online? Any questions? Seeing any? All right. Well, we'll say goodbye, and thanks for joining us again.
Thank you.
Thank you.
Bye all.
Bye.